All right, we're going to get started shortly with the next exciting panel. And also, as a public service announcement, I understand that Secretary Kerry is next door, and I know that this is a very rambunctious conference here, and we've been asked to kind of lower the volume a little bit to accommodate him. So, happy to do that. Good morning, and welcome to the next session. For those who don't know me, who aren't longtime Scott Ferber followers, I am Scott Ferber. I'm an Associate Deputy Attorney General at the Department of Justice, and I am here today for what I view as the most exciting presentation at today's conference, and that is information sharing through the lens of the recently enacted Cybersecurity Information Sharing Act. You'll excuse me for standing at the podium. I'm not trying to sermonize. Old habits as a federal prosecutor die hard, and I love having my podium and being anchored to it. But the Cybersecurity Information Sharing Act, or CISA, was enacted in December 2015, and very exciting in the cyber world. And you are all lucky today because you really have the lions of the CISA bar up here. And I'd like to just briefly introduce them. They have more extensive bios in your literature. But seated immediately to my right is Dianna Carr. She is Deputy Director for Privacy at DHS's National Protection and Programs Directorate. Immediately to her right, Josh Goldfoot, who is the Principal Deputy Chief of DOJ's Computer Crime and Intellectual Property Section. Seated next to him is Gabe Taran, who is Assistant General Counsel for Cyber and Infrastructure Program at DHS. And then at the far end, Sean Newell, who is Deputy Chief of the Counterintelligence and Export Control Section at DOJ's National Security Division. So we have lots of interesting topics to cover. I am definitely going to leave time at the end for your valuable questions. But I think a good way to kick things off is for Josh to, as a scene setter, discuss what is information sharing, generally speaking, from a cybersecurity perspective. So to you, Josh.
Thanks, Scott, and thanks also for the invitation. Let's think about how attacks typically happen against companies and other organizations. It's usually not the case that your outside hacker is going to go directly at your most important asset. It's going to go straight through the database or the file server that has everything on it. Their initial target usually is something smaller, like Wally in accounting. They want Wally in accounting. They want to be able to infect his computer, because once you get onto there, they have a foothold in your network. They can start attacking other computers, spread from there, and download things. So Wally in accounting, enormous amount of effort companies typically put into trying to defend against exactly that type of attack. What are they going to do to Wally in accounting? Well, they're going to typically try to get Wally to to launch an attachment or click on a link. They're going to take advantage of vulnerabilities in his desktop computer system. So for example, you could have a PDF, and if you're using an older, unpatched version of Acrobat Reader, some PDFs, if you open it, can install software on your computer. Once they install software on their computer, they own that computer. They can do to it whatever you want. That's where ransomware gets started. That's how the ability to run a program on that could download other things from your file server gets started. Another way to get on is to send him a link. He clicks on the link, that goes to a website that the bad guys control. It sends things that the browser didn't know how to handle, and before long they've installed software on there as well. So defending against this is a huge effort for cybersecurity professionals. Learning what the attacks look like is hugely useful. If you know, for example, what sort of PDF attachments they're sending out, if you know what the links are, or even more specific than that, if you know how they're trying to trick your employees into opening these things, that can be enormously useful information. So the idea with information sharing is that companies essentially help each other out. As soon as someone notices one of these types of attacks, they can take that email, or at least derive some sort of information about it. Maybe I'm not going to give you the whole thing, but I'm going to say they're targeting my main executives and they're pretending to be inviting them to a conference, and you click on this link. Share that with other colleagues in your industry, or even broader than that, and then they now know how to defend against that. That can go into this. So that becomes very useful. As lawyers, that becomes a question for us because lurking behind all that, of course, is things like privacy statutes that typically govern the extent to which providers of email service are allowed to disclose emails to people other than the customer that that's destined for. That was a complicated issue. I think that people managed to get through a lot of that with sort of terms of service and employee agreements and banners and so on. But what CISA does is answer a lot of those legal questions by resolving, as long as you meet certain criteria, you get authorization to share that information and also liability protection.
Thank you, Josh. And so that is a good segue. Maybe we could turn to Gabe now as to what information sharing looks like under CISA.
Sure, thanks, Scott. So I think my job is to translate what Josh just eloquently said into CISA lingo. So CISA basically authorizes the sharing of cyber threat indicators and defensive measures for cybersecurity purposes. So the first question is, what's a cyber threat indicator? And I think it's really kind of a technical rendition of what Josh just described. I could read you the definition. It's long. It basically says information necessary to identify an attribute of a cybersecurity threat. But in short, it's really an attempt to capture the techniques and methods that are being used by bad guys that could then be shared out to others so that everyone can sort of benefit and apply the protections. To give some examples of cyber threat indicators, one of them could be the internet protocol address, so some address on the internet that's sending out bad code, for example. It could be a security vulnerability, so a vulnerability in a security product may be associated with an IP address, so here's where the bad thing is coming from, and here's the vulnerability it's attempting to exploit. It could be either malware itself or a hash of the malware, so a rendition of the malware that allows a company to identify it and identify it as bad. Those are some examples or others of what a cyber threat indicator is. And then the other item is a defensive measure, which is related, and it really refers to the technique or procedure or method that you use to defend an information system against a cybersecurity threat. What do you do with that cyber threat indicator? So, okay, I have my cyber threat indicator. I'm a IT person at a big company. How do I take that and actually apply it? And that's where a defensive measure can come in handy. I should mention there's an exclusion in the definition of defensive measures. CISA has a lot of exclusions, a lot of clawback provisions. But this one basically precludes using this authorization to do what's called hacking back. So it says that a defensive measure that causes substantial harm to an information system or provides unauthorized access to the information system does not fall within the definition. And then when you're within those definitions, as long as you're sharing for cybersecurity purposes, the authorization in CISA to share applies. It applies notwithstanding other laws, so it sets aside other laws. And if you share in accordance with CISA, you get a variety of protections that I think we'll discuss a little later.
And Gabe, how, if at all, has information sharing changed as a result of CISA?
Sure, so I can talk, I think I know most about information sharing with the government since DHS operates, I think what's called the federal government's capability and process under CISA. Basically a set of technologies, one of which you'll get a demonstration of in an hour. We were sharing back and forth with industry before CISA. I think there was a period where industry was sort of waiting to see how it would all shake out. DOJ and DHS put out some guidance in June in final form. And we're now seeing sort of an uptick in information sharing. There's definitely some things that have happened that I can say, well, this wouldn't have happened without CISA, in addition to whatever was happening before continuing. It's looking like there's a sort of positive trend in the right direction, a bit of a snowball effect. But it is taking a lot of large companies some time to really understand what this is, build it into their procedures, decide as a business matter what they're willing to share now that some of the legal obstacles have been swept aside.
And what about sharing among private sector entities under CISA?
Sure, so CISA definitely authorizes sharing among private sector entities. It was intended to sort of do that just as much as address the topic of sharing with the government. Again, I mean, I think I have less of a sense about, regarding how much more or less private entities are sharing with one another. But certainly from the point of view of fielding questions and the level of interest, I think there's a high level of interest and a high interest in sort of converting this statute into an actual operational practice.
Maybe we could turn to Dianna now to talk about the privacy protections in CISA for sharing cyber threat information.
Sure, thanks, Scott. So I think there's a number of them, and I'll kind of highlight a few. The first is the requirement for both federal entities and non-federal entities prior to sharing to review cyber threat information and to determine if it's directly related to the cyber threat and remove any personal information that identifies an individual or that specific to the identity of an individual, and remove that information prior to sharing. So it's a caveat to review for personal information, determine if it's relevant to the cyber threat, and if not, to remove that information prior to sharing. It also allows DHS to conduct what we kindly refer to as our quote-unquote privacy scrub. So through one of the guidelines, we were able to come to a unanimous agreement with the other named agencies in the Act to a set of controls that DHS is allowed to implement and to review for information before sharing it back out. And also the definitions of a cyber threat indicator and a defensive measure is also a privacy protection, kind of limiting the scope of what information can be shared under the Act. There's also a set of limited uses, mainly for cybersecurity purposes, but also there's limited law enforcement uses for the federal government. And then through DHS's implementation using the structured threat indicator exchange, the STIX language, is also a way to control the information. So I think a combination of all of those really kind of highlights the privacy protections.
And Dianna, you mentioned that DHS conducts a privacy scrub for the information, the cyber threat information that it receives. Can the private sector just rely on that scrub and submit qualifying information, or does it have to, on its own, scrub the information before submitting it to the DHS portal?
So the Act requires, in order to receive liability protection, that an entity review that information, again, to determine if it's relevant to the threat, if it's not related to the threat, to remove any of that personal information before sharing. So in order to get the liability protection, that scrub has to take place within the private entity, and that's both applicable for private-to-private sharing as well as private-to-federal sharing to conduct that scrub. So in an example with an ISAO, say a company is going to share through an ISAO, which will then share through DHS. In order for the company to get the liability protection, it needs to review for personal information and remove any that's not related to the threat, and then the ISAO would then further do a review before sharing it to the government in order to have the liability protections carry all the way through.
Gotcha. So at this point, I'd like to turn to Josh and Sean and talk about private entity sharing of cyber threat information with other federal agencies, including law enforcement. And if you can talk about how that works and how CISA changes that, if at all.
Thanks, Scott. I think the simple answer is it does not change it at all. I'm in the part of NSD that has more investigative role involving intrusions by nation states and their proxies. So I was intimately involved in kind of the creation of CISA and how it was initially brought together. But I had to quickly become familiar with it because almost immediately after it was passed, we started hearing from victims that they felt they couldn't share information in the same manner with law enforcement as they had before because of the bill's passage, and they had a lot of concerns in that regard. But the bill actually says, the statute actually specifically says it does not impact, I think it's in section 105, says does not impact any existing sharing mechanisms with law enforcement and the protections that are provided through those mechanisms.
And so if it doesn't alter the existing scheme, why is it nonetheless important for private sector entities to be sharing information through CISA and the AIS portal?
So the distinction to draw on the one hand is between, is sort of why are you talking to the government?
Yes.
So if you want to report a crime, like I have been hacked, I want the help of a law enforcement agency. Same rules as always. No one was ever concerned about that as a potential liability event, that you would get sued for reporting a crime to the government. So CISA doesn't change that. It didn't need to change. It's the other part I was talking about, where the reason that you're sharing information with the government is that you have spotted a threat and you want to let other people know about it. You want to let government agencies know about it. You want to let other industry members know about it. Not because, this is the crime of the century or you want the cops to come down, just because you spotted it. That's where CISA comes in. That's where the information sharing comes in. So for that, as Diana mentioned, you have the basics. You want to make sure that you've extracted from it what the statute calls a cyber threat indicator, done the privacy scrub on that, had a cybersecurity purpose for sharing it, and then go forward. Liability protection.
And is private-to-private sharing allowed under CISA without submitting to the, or through the AIS portal?
Yes.
I agree.
Okay, so from an investigatory standpoint, Josh, you mentioned at the beginning the generally information gathering, but for investigations, what types of information are you looking for the private sector to provide to assist in your work? And I open this up to Sean as well.
In a law enforcement investigation, if we get called in, so obviously we want to figure out what happened and who did it. So helpful for that. Obviously, there's been some sort of malicious software, the infection. Being able to isolate that is very helpful. Logs, right? Computers, routers, everything, they keep track, of what's happened. Collecting those is useful. We're going to have interviews with key personnel as that goes forward. I'll say very often, with the larger, well-resourced companies, they're going to hire a cybersecurity firm to come in and do a lot of the internal investigation for them, and often also a law firm, such as many in this room, to help with that situation. We're always happy to work with either of those classes of professional as well, let them do some of the initial investigation and pull out from there. But
Scott, I'll turn back to the question you had just prior to that, which was, why is the sharing of information important? Obviously, as law enforcement, we always love it when the victims come to us and share the information about an intrusion they've discovered on their own with law enforcement. But I think it's equally important to law enforcement that victims or the private sector is sharing amongst itself for network defense purposes, because it's a very data-intensive process, our investigations are, and we often need lots of data to put together a picture of who's conducting activities. And if victim A shares with victim B, or shares with another company, and that company learns through the information shared with victim A that it has been targeted by the same threat, they may come to law enforcement and have a whole new data set to be able to provide to us that enables our investigation. So enabling network defense also enables the law enforcement response as well, and that's why this is a very important mechanism in our eyes.
And are there implementation guidelines that would assist the private sector in understanding the language of CISA, how to share information, the privacy protections involved, and things of that nature?
Yeah, so CISA required DHS and DOJ to put out a set of guidelines, or 4 documents. We had to put out interim guidelines in 60 days, which the time frame in an application of Murphy's Law started before Christmas, ran through Snowzilla, and ended the day after President's Day. But we got it done. We got them out on the website, and then final versions went out in June. And so there's basically 4 documents. One, which may be the most interesting to this audience, is the guidance to non-federal entities about sharing under CISA. So it's really, if you're in the private sector and you want to understand this in English, or at least closer than the text of the law gets you, that's your key document. There's also a set of privacy procedures that basically apply to the government, but are also a good sort of indication for everyone else. There's an operational procedures document, which really talks about how principally the DHS capability works. And there's also a document kind of cataloging the various ways that the government shares back out. A lot of the text in CISA about sharing with government is about the government's receipt of information, but Congress was also concerned about ensuring the government was sharing back out, and we certainly do. So there's a good sort of compendium of documents there. Those documents are available at the web address that I think Suzanne mentioned earlier, which is www.us-cert.gov/AIS. And basically, they're publicly available.
And just a plug on the guidelines, it really was a great example of harmonious collaboration between DOJ and DHS in putting together some very intensive and I think helpful guidance on an incredibly short runway. So hat tip to all of you for doing that. I'm sure a lot of people here are interested in the liability protection provisions under CISA. And so maybe Gabe, or Josh rather, if you could quickly talk on, generally speaking, what those are, and then we can drill down a little further on those.
Sure. So basically, if you follow the procedures in the statute for how to share information, there is no liability from that. And that's one of the broadest exemptions from liability you're going to see in a federal statute these days, with all the bells and whistles, preemption of state law and everything. You cannot be sued for anything, breach of contract, privacy statutes, anything. So if someone does sue you, that's a motion to dismiss. You can farm out to a first-year associate. Good. So there's more. So there were some people who were concerned that, particularly when you have members of one industry sharing this information with each other, that was potentially an antitrust concern. Actually, DOJ's antitrust division wrote a paper before CISA came out saying, don't worry about that. That's not an antitrust concern. Nonetheless, for anyone who is still worried about that, there's protection against antitrust liability, so that's written in there specifically. Freedom of Information Act, right? People are worried that if you give it to the government, then it can get FOIA'd by someone else. Actually, right there in the statute, both state equivalent and federal FOIA is exempt from this. What else? Waiver of privilege is the other one people are worried about. If the thing that you're going to disclose, maybe that was protected by attorney-client privilege or something, does disclosing in the portal rule the privilege? Again, that's specifically in the statute. You do not waive privilege by taking it through there. So really, I won't go through everything, but they really thought of everything. Like there's no longer a legal excuse not to put something into this portal.
So on that subject, and again, not exhaustively covering everything that's protected or exempted under CISA, what if I as a company, have this widget that is proprietary, contains trade secrets? I mean, can I designate that information be protected or treated differently than the garden variety information shared through the portal?
Yes, you can designate as commercial, financial, proprietary information, and it gets the appropriate treatment.
And doubling back a little bit to the liability protections, do they cover network monitoring by a private sector entity?
So network monitoring, so this is separate from the information sharing part of CISA, but yes, there's an authorization in there. You're allowed to monitor your own network for cybersecurity purposes to defend against cybersecurity threats. The reason that's in there, I mean, you could do a lot of that before, but people worried about things like the Wiretap Act, which was originally 1968 and then updated in 1986 to include computer communications, the Electronic Communications Privacy Act. People worried about that and the Penchap Act and the extent to which, and so the big workaround for the most part was employee agreements because it had a consent provision. So you make all of your employees consent to have that monitoring.
And that consent can be the banner we all see before we...
Yeah, but at least of us in government. And when I worked in law firms too, I think I consented to a lot of stuff without knowing. So CISA really updates that for us. And again, for lawyers who had to give advice about what sort of cybersecurity measures were necessary, it's now just very easy. Yes. Is it your own network? Yes. Or were you paid by someone to monitor someone else's network? Yes. And is it for a cybersecurity purpose as opposed to a more nefarious purpose? There's an affirmative authorization now, notwithstanding any other law, to do that monitoring.
But I think that's an important point to underscore, is that with network monitoring, for the liability protection to apply, I mean, it has to be for a cybersecurity purpose, right? So for example, if you're, or a company is investigating employee misconduct that doesn't have a nexus with cybersecurity purpose, then the CISA liability protections wouldn't necessarily apply.
Yeah, I think that's right. And so definitely don't throw away your employee agreements, and you might want to keep the banners on there, because there are going to be things like that, internal investigations and others, where you want to be able to access that stuff. But as far as looking at your own network traffic to protect your own network and your own property, there's no longer a legal concern with that, in my mind at least.
And Gabe, did you have something to add?
I was going to make the point you just made.
Okay, very good. Well, see, this is, again, DOJ, DHS, collaborating, sharing the same mind. Yeah. One of the panelists mentioned sharing with ISACs and ISOWs, and I just want to pull on that thread a little bit. What if a private sector, we'll go to law school hypotheticals, a private sector entity shares with its ISAC or ISOW, and then, in accordance with CISA, but then the ISAC or ISOW doesn't take that extra step of then sharing through the DHS portal? Does the private sector entity still qualify for liability protections?
Sure, so I can answer that. I mean, essentially, CISA provides liability protection for whatever act of sharing you're doing. So if you're a company, you share with another company, you get liability protection for that. ISAOs generally are private entities. These are information sharing and analysis organizations that basically organizations that are created to facilitate sharing within a particular sector of industry or region. They generally are private, so they're treated the same as any other private entity under CISA. And there's no requirement to share with the government. I mean, obviously an ISAO can, and they often serve the function of anonymizing information from their members and sharing it on. And that act is liability protected too if done in accordance with CISA, but it's not a requirement to do it. The company can share with an ISAO and have it go no further.
Dianna, looking at the privacy implications of sharing with ISACs and ISAO, should a private sector entity do their initial privacy scrub before sharing it, or can they rely on the ISAC or ISAO to do the scrub and still qualify for liability protection?
So they should do the scrub prior to sharing if they want the liability protection. So the private entity should do that review, remove the personal information that's not directly related to the threat, sharing it before sharing it with the ISAO. Then further, if the ISAO is going to share on with DHS, they would also do kind of their version of a privacy scrub in order to receive liability protection for that act of sharing as well.
And I would maybe add that the privacy scrub can be automated as well as human, so it doesn't have to be this like incredibly laborious, costly process. I mean, Dianna can probably elaborate more on that.
That's right.
And on the information sharing component of this, and not talking about liability protection, but once DHS ingests the cyber threat information through its portal, I mean, how quick of a turnaround time before it's then shared with participants?
I mean, it's machines doing it, so it's basically real time. As said, we do apply a privacy scrub, but that's essentially automated filters for an enormous percentage of it is all that happens. If the information hits a filter, then it would sort of go for human review. But we are statutorily required to share with a number of other agencies, and we've basically invited even other agencies to join our program, and so they're all gonna get this in basically real time.
And so I can add to that just a little bit. So some of the technical mitigations that we've implemented are through the AIS STIX profile, and there's things like schema restrictions, so fields that are simple yes, no's, or true, false data elements. There's regular expressions, so pattern matching that can be used, ensuring that an IP address is a series of numbers with periods. Things like that helps us automate the information coming through, and then anything that meets that criteria goes through, as Gabe mentioned, in real time, and only those fields that fail those automated checks are what get held back for human review. So if you're submitting a series of IP addresses, those that are formatted correctly, those will go through in real time. Only maybe one that has an error or that's not formatted correctly would get held back. A human would look at it, and then through STIX versioning feature would get updated and sent through. So I think it's an important point to know is that if something does flag for human review, we're not holding up the entire indicator. We are sending through everything that passes the automated scrub and only holding back that piece of information that needs a little extra review by a human analyst.
And must all personal information be scrubbed from a cyber threat indicator or defensive measure before submitting or sharing?
So no, CISA is clear to say that not all personal information must be removed. It's only information that's not directly related to a cyber threat that an entity knows at the time of sharing to be personal information of an individual or information that identifies a specific individual. So if that information is related to the threat, and it's personal information, that's okay. It can still be shared. And unfortunately, there's no hard and fast list that we can provide to say, these 10 data elements or these 50 data elements need to always be removed. It's not that easy, but we do provide in both the non-federal entity guidelines and the privacy and civil liberty guidelines some examples of types of information that would most likely need to be removed prior to sharing.
And Sean, maybe you could touch on whether sharing with law enforcement outside of DHS creates new liability exposure for a company.
So the simple answer is CISA does not create new liability where none existed before. But that being said, and it also acknowledges that CISA is not designed to address sharing with law enforcement. But nonetheless, if you look at Section 105, there actually is a provision in there that says if you do share information with DHS, CTI, you can then share that with law enforcement and obtain the liability protections that CISA offers. So although our message is there are no liability pitfalls by sharing directly with law enforcement, you have that provision that allows you to get some under CISA if you first share with DHS. There's also under the same section, Section 105B, I believe, no, C1B, a provision that allows entities to share with their regulators, even if they don't share directly with DHS first. So that's another way to get liability protection under CISA.
And are there other protections in play for cooperating with law enforcement?
Yeah, I think there's, as Josh alluded to earlier, no one was ever being held liable for cooperating in a law enforcement investigation. There's lots of, there's a statutory, there's lots of different statutes that deal with law enforcement cooperation that create exceptions to the Wiretap Act and things along those lines for cooperating with law enforcement. And, those exceptions to liability under those statutes still exist.
And what about if a private sector entity shares inconsistently or doesn't follow the CISA rules? Are they subject, or does CISA, well, let's focus, does CISA create civil or criminal liability for sharing that is inconsistent with CISA?
No, it does not. We like to say that CISA is your friend. It is really a statute that enables, does not sort of penalize. The regime is basically you're authorized to share. If you do it under the statute, consistent with the statute, you're eligible for a bunch of protections. If you don't do it under the statute, you don't get those protections, but the worst that happens to you is you're just back in pre-CISA information sharing world. There are no negative consequences, and there's a number of savings clauses about not using the fact that someone didn't share negatively, so the government really can't do that.
And on the, are there oversight processes in place in CISA for information sharing and privacy protection?
Yeah, so I think the guidelines are a good, oversight process built in. It's guidance provided both to, federal entities and non-federal entities on how to conduct sharing that's in accordance with the Act. There's also some GAO and IG auditing requirements, both at the 2 and 3 year marks on agencies for sharing under CISA. We have the AIS terms of use that needs to be signed by private non-federal entities before sharing, which kind of outlines the rules of play, if you will, on how to participate. And so I think there's a number of things embedded within CISA that kind of serve as a level of oversight. And then internally within DHS, something that we've been doing with our cyber information sharing programs for a long time, but that will be carried over into the sharing done under CISA, is we conduct oversight reviews on a regular basis to ensure that our privacy scrub is working and that the information is being shared kind of in accordance with the Act.
And I guess I'll keep you on the hot seat for a minute. Should a company notify its customers or clients if it's participating in CISA and sharing qualifying information?
So I think that, it's up to the individual company to determine, all of you here are in a counsel office for your company, so to determine what laws apply within your sector and what your requirements are. And I can turn it over to some of my other attorney colleagues here, because I'm actually not an attorney. So to further
play
answer.
one on the panel.
But really, it's going to be up to the company to determine, what requirements are on them, given your sector, and if you're an international company, things like that.
I mean, I would say it certainly seems like an emerging best practice, particularly if you think of companies looking even internationally to frameworks that might apply outside U.S. borders, to be transparent with customers and have notice and choice and those types of principles implemented. It is not a legal requirement under U.S. law that I know of.
And I'll open this up to the group, but what challenges do you see for the private sector when it comes to information sharing under CISA, and are they legal challenges?
Well, I guess I'll start. I haven't heard much about legal challenges. I think there are challenges that I would describe as cultural, and I think there's a variety of types. One of it is businesses just thinking that if I share things with my competitors, I'm making them stronger, and if they have a breach, isn't that good for my bottom line? Which is probably not sort of the most efficient way to think, even if you're just focused on your bottom line. There's also just risk aversion, which I think is coupled with sort of fear and lack of understanding, right? Cyber is a very new area. An attorney that's maybe kind of new to it and hasn't really fully engaged with it might be more risk averse. It might be easier to identify the problems with sharing or the possible negative consequences than the benefits. You know, the prescription, I think we often advocate for that, is to engage early and often with your clients. You don't want to first be introduced to the topic of cyber when there's a breach. You really want to be working with your IT professionals throughout the life cycle and really kind of understand and be a part of what they do, a part of their processes. They are trained to involve lawyers in a number of different things. And I think if you do that and you get a good sense of how this works as an industry, like any other industry, you'll have a greater comfort level with these things, which include information sharing, which at the end of the day, I think we all think is a beneficial thing for any business to be doing.
So I just want to piggyback off of one of the things Gabe said, because I agree with everything that he mentioned, but I think that there's some level of, like you said, risk aversion to, you know, do I want to put this information out there? Will my stakeholders or my shareholders then interpret it as, you know, my company is, you know, in trouble? And so sharing through the DHS portal is allowed to be anonymous. You have the option, so say if you're a security researcher and you really want to tout the fact that you found this great vulnerability, then you can say, I consent to share my identity with the federal government or with other private entities. You can also opt to say, well, I only want to share with the federal government, I don't want to share with entities, or you can say, I don't want to share my identity with anyone. So I want this to be anonymous, and then as it'll go through, the identity, the company's name will be removed, and it'll simply just say that it's coming from DHS under this AIS initiative. So I think that that's something that will help with the level of risk aversion, is that you don't have to disclose that you're the one sharing this information.
And before we open it up to questions from the audience, does anyone on the panel have any parting shots? Seeing none, and I do definitely want questions, but an exciting announcement as part of this presentation. Although not statutorily required, in the spirit of ongoing collaboration between DOJ and DHS, we are going to be soon issuing frequently asked questions, and so some additional guidance to you all. And those are under construction, nearing completion, so stay tuned for that. And with that, sir.
This is great. Thank you guys so much. I have one practical compliance question. CISA is a fantastic way to simplify U.S. law with regard to sharing information that is received in the United States. For our multinational clients, though, they face pretty sharp restrictions on things like sharing without even revealing that they're doing monitoring without going to Works Council and the like. I'm curious if, since this is a global threat environment, if the U.S. government has had discussions, and perhaps through DHS, with European data protection authorities about creating a protocol for data minimization that might bridge some of these sensitivities in Europe around sharing specifically threat indicator information.
Yeah, and you know that can be the elephant in the room sometimes, the international aspects of this, particularly on the EU side. There's been at least sort of a desire for those discussions to happen, although I don't know that they've really started in earnest. I would say, I mean, I think the problem sometimes can be subdivided a bit. While the EU protection regime probably applies to some amount of the universe of what a company might share under CISA, and might have some implications, that doesn't mean that it applies to all of it or that nothing can be shared. If you think of a hash of a malware program or things like that, maybe that might have less implications than IP addresses, and even IP addresses may have some definitions that can be helpful. So I think we don't have a neat solution negotiated between our governments to present to you today. I think the issue's been raised and it's one that's being thought about, and I think it sometimes appears like this giant wall that stops companies from sharing, and I think there's probably sort of more granular approaches that can be taken to the issue.
I completely agree with you, but making this seamless and easier to use, I think this would be a great, obviously you have to set up the program, and you're doing a great job getting the word out. This would be a great next step in work, because it really makes this very, very broadly out.
Yeah, no, that makes sense. And I will say we do have, foreign countries and foreign companies expressing interest in even joining the program too, which may include EU, or at least current EU. But yeah, the issue is very much being thought about.
Any other question? Yes, table 8.
So who makes the determination as to whether personal information is relevant to the cyber information sharing? Is it the company itself? Because I could see an eager CISO wanting to share probably more than he should with the government and erring on the side of security more so perhaps than privacy, and perhaps oversharing. And it sounds like there's not a lot of guidance as to what is personal information necessarily. So is that a potential risk?
So you bring up a good point that, so CISA doesn't provide a specific definition. It uses the caveated phrase, personal information of a specific individual or information that identifies an individual. But it is up to the organization who does the sharing to determine the relevancy to the threat. And through the guidelines, both at the federal level and at the non-federal entity guidelines, DHS and DOJ try to think through that to provide as much guidance as we felt appropriate and as we could, as to how to go about making that determination. But it really is up to the organization that is sharing. If you're sharing through the automated capability using the STIX profile, we have thought through and made the determination of what constitutes a cyber threat indicator and a defensive measure, and that's the types of fields that are provided. Once you sign the AIS terms of use, we do provide submission guidance that kind of goes into more detail and provides additional guidance as to the types of information that we're looking for in individual fields that will help with that determination. And so that can, between the guidance and that additional submission guidance, I think that can help, but ultimately it is up to the organization that's doing the sharing.
Any other questions? Yes.
Have you come across issues where a company has a service provider who's doing cyber investigations or providing security services, and how they're working out who shares, who decides when to share, when the monitoring may be done by a third party for the investigation, whose information is that indicator?
Yeah, that's actually coming up a lot. There's the case you laid out, but there's also just the cyber threat providers, so companies that just provide a platform for their customers to receive cyber threat indicators and analyze them and share back. I think you could question whose indicator it is, but I think those companies, for business purposes, are being pretty cautious about getting their customers' consent to share on. I think one of the sort of surprises in DHS's AIS program has been that model seems to really be taking off. I might have thought that cyber threat companies would be the most reluctant to share, just because they do monetize cyber threat indicators. It's seeming like it's the other way around, and they really want to give their customers access to this program. So I think there is a lot going on there, and I do think generally it's still treated as something the customer would have to consent to.
Any other questions? Yes.
The portal is a wonderful, wonderful tool for
Are you a DHS plant?
Hey, well, I'm going to ask you about the side of this about what we want typically to do. It's a wonderful tool for entities that are more sophisticated. Is there a way to make this scale even more easily to subcontractors, entities that are part of ecosystems that really need to be sharing information that could create a very healthy, virtuous cycle of sharing within the ecosystem and then sharing more broadly with the government? You guys thought about how to make this super easy for unsophisticated players to use?
Yeah, we do, and as Suzanne said in the previous panel, we do a lot of sharing with small companies. A water treatment facility might be very small, but very critical as well. I think, you're right that to connect to the portal, you need to speak geek to some extent. I think some of the answers to that are in, what we just discussed with cyber threat companies, where, might just be a customer, or ISACs and ISAOs that can maybe take the information in a more raw form and help you convert it. We also recognize that though we want to encourage everyone to go towards our automated capability, not everyone's going to be able to or want to, and so we do have a plain old web form on our website and even an email address that we've tried to bury as much as possible because it increases our workload, but it is there. So there are ways for less sophisticated actors to get information to us. In terms of the sort of societal problem of getting small and medium businesses to share, I think I would point to the work that's going on with developing standards for information sharing and analysis organizations as probably our biggest effort in that area right now.
I think we have time for one more question. Yes, please.
If I'm an entity that has a compliance requirement, and by this I mean either a statutory or a contractual relationship with the government that I have to tell them about certain incidents, and I was to report through this portal, would that suffice? Am I in a safe harbor such that, you know, as was mentioned, PPD 41, reporting to one is reporting to all, even if it's either I did it intentionally, or because I didn't at the time know that I should have reported the other way. But am I sort of in a safe harbor that I've told the government, and that if there is a statutory or contractual requirement to tell the government that I've done that by sharing through the portal?
Typically not, unfortunately. I mean, typically the type of information that is meant to be shared in those requirements does not line up so well with what a cyber threat indicator is. It's more sort of incident specific. There is that liability protection for sharing with regulators that can get you part of the way. But typically, you know, if your regulator or your contracting agency has a requirement to share something, I think you want to go through those channels.
Well, I just want to thank our panel for an excellent presentation and the audience for your great questions and attention. So thank you. One quick note on lunch, because that's where you're going next, or rather staying. For those who ordered, your food is available and you should pick it up and also pay. And for those who haven't ordered, there are extras, so you can pick that up and pay too. Just to personalize the payment issue, Kiran Raj, who Stephen acknowledged at the beginning of this, will be on the hook for any lunches taken and not paid for. So please remember to pay. Thank you very much.
I'm definitely not paying now.